back, and I have a good topic for you today. I'm going to be talking about applying for the green card based on an ex spouse. Yes, that's possible, and you can do it. You can get permanent residence based on an ex spouse who mistreated you. So, in order to apply for your own permanent residence or your own work permit, you would have had to have an ex spouse who mistreated you. A lot of people think that once they have divorced the spouse, that there is no hope for them to get permanent residence or their work permit. And I'm here to tell you that that's not the case. If this ex mistreated you, then you can apply for your own work permit and your own permanent residence through VAWA. But the clock is ticking. When you have divorced your spouse, you have up to 2 years to be able to apply for your work permit and your permanent residence. If it goes over 2 years or more, then you will no longer qualify for this. So at the point that you have divorce, file for divorce, or you finalize your divorce, then you know that you only have a limited amount of time to apply for this. This also applies if if the ex-spouse died, or, well, we're talking about spouse. So if your spouse passed away, you didn't divorce them, but they passed away instead, you have 2 years. So keep that timeline in mind. You do have a deadline. Uh, Now, I want to talk about this kind of application for your permanent residence in two different situations. The first is that you were married to the spouse. Now you divorced, and you never applied for permanent residence, or you may have applied but you got denied. And maybe that denial is also related to the mistreatment. And then the other situation is where you received your 2 year permanent residence and you then had to divorce the spouse, maybe because they were mistreating you. Maybe they weren't mistreating you. Maybe it just didn't work out. You can also apply for your 10 year on your own without involving the ex spouse. And mistreatment is not required in this case, where you already have your 2 year and you're going on to your 10 year permanent residence. But you do have to show that the marriage was real, despite it not working out. It was real. You did enter the marriage in good faith. It's just that it didn't work out, or that you had to leave the spouse, divorce the spouse because of mistreatment. But in this case, you are able to apply for your permanent residence, for your 10 year permanent residence, even if you're divorced. So you can always get in touch with me and we can talk about that. And then, of course, I'm sure you have some follow-up questions. It would be perfect to talk with you in the consultation to determine whether you qualify. Because, one of those sad things that I realize is, like, a lot of people, you may listen to the live and you may say, oh, that's not me. I don't qualify, because maybe they never hit me. They mistreated me, but they never hit me. And then you basically take yourself out of the running before you even find out whether you qualify. So this is where I reserve the consultations to evaluate your facts and determine. Have an attorney such as myself evaluate your circumstances. Don't jump from A to Z and say, I don't have proof, though. I can't show it. I can't. If this happened to you, then let's talk about it and determine whether you qualify. Because if it happened to you, you have a real good shot at this. Now, I want to address that question, though. Okay, yeah, my spouse definitely treated me very badly. At times they were just downright cruel to me, but how can I prove this? They never hit me. They may have threatened to hit you, and even if they didn't threaten to hit you, they may have done it in a way that wasn't physical or no threats of violence, but they may have called you names, or they may have yelled at you. They may have done vindictive things against you. They may have threatened you with ice. They may have intentionally delayed getting your paperwork because they wanted to control you. They may have treated your children badly. All of this also counts to qualify you for permanent residence and your work permit in the United States. And in the case that you already have your 2-year permanent residence, you can get your 10-year based on this behavior. It does not have to be physical violence, threats of physical violence. And that brings me to the next thing, is that you don't necessarily need medical records and you don't need police report to show this. Attorneys, unfortunately, some attorneys may be misinformed, and they may tell you that, oh no, this is not going to fly because they never hit you, or oh no, you have to find another way because you don't have a police report, or you don't have any medical records showing physical injuries as a result of the abuse. This is not true. Abuse and mistreatment and extreme cruelty, all of which qualifies you for VAWA, comes in different shapes and forms. It's not, domestic violence doesn't just include physical violence or threats of physical violence. It includes other behaviors against you. And so you should not discount yourself or take yourself out of the running based on your own self-evaluation. Get an attorney who knows what they're doing to evaluate your situation. And this is what I do. I do help my clients to get relief based on mistreatment from a spouse, from an ex-spouse, and from a parent, from an adult citizen, adult child. So there are different situations. I'm talking about the ex-spouse today, but if you have a parent or you have an adult citizen child who has mistreated you, this could also qualify you as well. Now, with the parent, you do have to be under 21. If you're not under 21, you can't reach the age of 25 to qualify. In some cases, you can apply up to the age of 25, but it's going to depend on the circumstances. So that's what I have for you today, right? Is don't sit down and take yourself out of the running because you think you don't have proof. You'd be surprised what will be accepted as evidence, including your statement. So if you have a clear memory of what happened to you, and sometimes the trauma of it you may have wiped some of it from your memory, but you have enough facts for an officer to put it in a statement and for an officer to determine that you qualify. It's worth pursuing this. They accept any credible evidence. That means that any evidence that's believable, including your statement, we call it a declaration, and it's a certain document that we put together based on your statement, but which is focuses on the details that the officer needs to evaluate whether you qualify. So get in touch with me. We are open right now. Scheduling coordinators are available to take your call, and you can also schedule your own consultation. You can do that by going to the link in the profile to schedule your own appointment. It's really easy. So don't hesitate. Go do that now so we can evaluate what your circumstances are and whether you qualify. Now I'm going to take questions. It can be anything that's immigration related. It does not have to be just about this topic. So go ahead, put those questions in the comments so I can get to them. I already see one on YouTube, so I'm going to go ahead and answer. So good morning, good afternoon. I have 2-year green card and filing for divorce based on cruelty assault. Must the reason for my divorce be based on cruelty assault to be able to apply for the 10-year when filing for the I-751? So this is in reference to what I talked about previously, having the 2-year and you're going on to the 10-year. Now, when you have already divorced a spouse, in this case, you're filing, you don't have a final divorce decree. It sounds like you have two bases to apply. You can apply based on a waiver and you can apply based on assault and cruelty. Of course, I would suggest that you do not do this on your own. You get legal advice, and this is what I'm available to represent individuals on and also to advise on. So schedule that consultation because the evidence has to be very specific and you have to make sure you're approaching it in a way that the officer can understand you qualify. But you can submit multiple waivers to go from the 2-year to the 10-year without the spouse. So one is the divorce and proving the marriage is real. And then the other is divorce, the marriage is real, but also that you face extreme cruelty or abuse. So in a nutshell, the reason does not have to be only based on extreme cruelty or on abuse or mistreatment. It can also be that you just got divorced, it just didn't work out. That's why this waiver is available, because they know that sometimes marriages don't work out. I think the last statistic I looked at is like 50% of marriages fail. So this is basically the backup plan for an individual who got their 2 year, who ended up getting divorced, but they still want to make sure that the marriage is real before giving you the 10 year. So great question. Can I still get my work permit and social after I file, but my spouse threatens to get a divorce? So if the spouse threatens to get divorced, it's not a divorce, and sometimes spouses threaten to divorce you. Now, if this is something where they're using it as a pawn for you to comply with their needs or comply with what they want you to, then this could possibly be a basis for VAWA for you to continue your process. So if you've already applied, you can switch from that process involving your spouse to a process by yourself, whether you're living with a spouse or not. That can often be a way to protect yourself, especially where this spouse is constantly threatening to divorce, to leave, to cancel the paperwork, to not show up at the interview, to contact immigration. And actually, I would say this: if a spouse is saying this, threatening you, saying, I'm going to call immigration and I'm going to cancel the paperwork, do not take that for granted. Believe them. I have seen spouses do that behind the immigrant spouse's back and sabotage their immigration process. So if your spouses don't do that, right? Caring, loving spouses don't do that. They're not going to use divorce. They're not going to use the immigration process against you. And if they're doing that, believe what they're saying, because they will do it. And I've seen these kinds of spouses do that. So you definitely see if you have options to apply on your own, because that option is available to you, and it can be a self-protective process where you can take the process out of the control of the mistreating spouse, so that they're not sabotaging your papers, they're not leaving you out in the cold, they're not leaving you undocumented, they're not canceling the paperwork behind your back, because I have seen it and it does complicate the situation. It can be a fixable situation, but it's a little more complex. So if you're going through the process now and you want to switch to your own process and take that spouse out of the process, there is a way to do that. And I have done it for my clients, and they're happy right now that they have a peace of mind, because they're able to take that process and put into their own hands, instead of this spouse who was constantly threatening to cancel the paperwork, threatening to call police on them, threatening to call ICE, threatening to get get them deported. So, it gives you a certain level of peace of mind as well. Hello there. My friend F1 status was canceled, but he lodged a 485 adjustment of status and haven't gotten any approval notice yet. It was citizen spouse case. Can he still use his I-20 for his driver's license? So if his F1 status was canceled and he does not have a grace period, then that they're not, and they look at the deadline. But using the I-20, they sometimes can verify whether that status is valid or not. But seek legal advice, because this is a little more complex. Through the adjustment of status, through to the citizen spouse, they're able to get their work permit and the social security number. So that can be the process that allows him to continue to get the driver's license. But when does the I-20 expire? When was the status canceled? What was the reason for the cancellation? All of this is going to be very important in evaluating options going forward. All right, keep putting those questions in the comments. If you file for VAWA and you are with a green card holder, will it prevent them from getting citizenship? So that's a good question. And it depends, right? Because it may bring to the attention of the Immigration Service situations that raise good moral character issues. So if for example, if the spouse, the immigrant spouse, say they had an affair that resulted in the separation of the two of you, and that played into the extreme cruelty, that could very well come back if they do note this. It could come back to haunt them in citizenship because it's information then that would prevent them from getting citizenship. What I would say in the case of my clients, I don't represent the spouse. My priority is not that person that's the abuser, or they are the one that's subjecting my client to extreme cruelty. I am responsible for my client protecting themselves against deportation. And so I'm not obligated to then try to protect the spouse or the other relative. In some cases, it may affect them. In other cases, it may not, right? So, for example, if the child, if this is based on citizen, say a citizen spouse, and the citizen spouse is of course, they're already a citizen. They're not subject to any kind of immigration review. And then it comes out that this citizen spouse was a drug abuser. Is that going to get them in trouble with the police? No, because the Immigration Service, they cannot disclose this information to outside agencies. It's actually against the law for them to share information outside of the agency. And so they will not be calling the law enforcement to investigate the drug abuse of the citizen spouse. However, when it has something is disclosed in the application that has something to do with maybe their eligibility for another benefit, of course, for instance, if in the case of trafficking, the trafficker can never, they become inadmissible. They cannot get citizenship. And so if it comes out that in someone else's application that this person was a trafficker, then they could very well be banned from citizenship. So it all depends. But I am protecting my client, my immigrant client. I'm not protecting the interest of the abuser or the spouse that's mistreating my client. I'm trying to keep my client from being deported or from getting in trouble with immigration themselves. Can I still get my social security number? Okay, so I answered that. How much should the spouse be earning a year for them to support a wife and 5 kids in total? Go to the I-864P form, and it's all there. What if your spouse stopped the paperwork while waiting on an interview date and the person is not in the States? Can the person still get their green card? In some cases, if this spouse is a member of the military or they are the employee of the federal government, then that person outside of the United States can go ahead and apply for this type of relief through VAWA, but not just because the spouse stopped the paperwork, right? Keep in mind that some sort of pattern of mistreatment has to be involved. Mistreatment or extreme cruelty has to be involved to be able to qualify for this. It is still within the citizen's right to cancel the paperwork if they wanted, as long as it wasn't based on mistreatment, like they weren't doing it to get back at the immigrant spouse, but they can still do that. So stopping the paperwork alone isn't enough. But what I often say is that is a sign that there is some mistreatment going on, or there's some imbalance in the power dynamic within the relationship, which leads me to ask more questions about whether the immigrant spouse qualifies for VAWA. Can a person being filed for I-130 apply for a B1, B2? Yes, but you have to really come good with the evidence and information to prove to the officer, reassure the officer that you are not at risk for coming here and overstaying. All right, I'm scrolling through for more questions. So go ahead and put your questions in the comments. Now is the time to put those questions in the comments so I may answer. Okay, so the I-20 is expired, but visa is still valid for 3 years on passport. The biometrics are done. So go ahead and get legal advice because your situation is a lot more complex and you need to make sure you get the accurate legal advice. So you're asking very, very specific questions. So that means that if your friend is in this type of situation, they need to make sure they're covered. How long does the process take when filing for a spouse as a permanent resident? So, 5.5 months is the shortest I've seen in the US from beginning to getting the green card. And then outside of the US, you could be looking at 18 to 24 months to be able to get through the entire process if you're outside of the United States. What causes that lengthy process outside of the US is waiting for the interview at the embassy. Is it possible to get a green card without going to an interview? Yes, if the application is submitted and it is presented, and it is presented in such a way that the officer has no questions and they're confident that the marriage is real. If they have questions, they're going to schedule the interview. And right now, they're waiving interviews, so that is happening. But it means that the application has to be a good application. Great questions. All right, so I'm going to tell you how to get in touch with me. Go ahead, go to the link in the profile, and that will lead you to the website with all the buttons to access the website. Schedule your own consultation without even calling. So go ahead and do that. Now, when you go to the website, you'll see the phone number. The phone number is also all over my videos, on every single one of my videos. So you can also get the phone number from there, call, schedule an appointment with the scheduling coordinator if you need assistance scheduling that appointment. Can a person being filed for apply for B1, B2? Yes, that's possible, but you have to prove, reassure the officer that, or convince the officer that you will not overstay. Because when they see that that you're being filed for, meaning that you're applying for the green card, they immediately think, do you have immigrant intent? That means, do you intend to come to the United States to live? So if you get the visa, are you going to come back? You have to show that you're going to return. I have been waiting on my social for 10 months. I filed for my son and myself. My son got his after 2 months, but not me. Why would this be? I wouldn't know. I would have to look at your matter. It just depends on a number of factors. It may not be anything, or there may be, they may need additional information, but they usually send a request for evidence. But I'm not your attorney, so I wouldn't be able to tell you what happened there. All right. Thanks so much for your time. I'm going to be back tomorrow at around noon. So go ahead, look out for me, and I'll answer your questions, and then I'll come with a good topic. You come with your questions, and we will talk. All right. So have a good evening, everyone. Bye bye.